Kenyans in general. I'm here to give my statement on what transpired at the Supreme Court yesterday. And I'm not here to criticize anyone or to attack anyone. We respect the judiciary. We respect the outcome. However, I'm here to talk about how the court conducted itself in arriving at the judgment in question. I've seen there are some headlines our opponents are celebrating, saying this is the end of Sonko. I want to prove them wrong and tell them it is the start of Sonko, not the end of Sonko. So without wasting a lot of time, I want to go to the matters in question, especially how the Supreme Court conducted itself yesterday. And this should not happen again to any other aggrieved Kenyan, not even a politician, Kenyan. We remember very vividly there was a preliminary objection filed by the respondents. The respondents wanted my appeal to be struck out by the Supreme Court. They alleged that the appeal was not filed on time. The matter was heard. There was a plan even to dismiss my appeal during that time. So the judgment of this case was supposed to be delivered virtually on the 11th day of July. There was a contradiction on how these dates were given. I have a communication here with me, a notice of delivery of judgment from the Supreme Court. First, the judgment was supposed to be delivered on the 8th of July this year. That was on Friday. And I want to make it clear this was a separate judgment on the preliminary objection on the filing of the appeal, whether the appeal was filed on time. I have a communication with me here from the Deputy Registrar of the Supreme Court. Amended notice. There was a notice first for the hearing to be, the judgment to be delivered on 8th of Friday, sent to the Supreme Court. Then it later changed. From Friday, they gave another hearing notice slated for 12th, Tuesday, July 2022. Then at midnight of 8th, they brought another notice for judgment delivery. This time stating the judgment for 11th Monday, which was a public holiday, which is okay, because the Supreme Court can sit even on Sunday, depending on the nature of the case. So the matter pending for judgment, the judgment was delivered on the 11th via email, and I have a copy of that judgment. It speaks for itself. On page 3, the judges are saying, we now determine as follows. Paragraph 9, subparagraph 1. There is no doubt that the appellant filed a notice of appeal at the Court of Appeal on 8th of March, 4 days after my impeachment dismissal at the Court of Appeal. This is showing some seriousness and commitment that I really filed my notice of appeal on time. And the receipts and everything we filed on time. Then, paragraph 2, the judges are saying there is also no doubt that the appellant filed his petition of appeal on this court online platform on the 4th, 2022. I was also on time. This is 3 months ago. Now, after filing the appeal in the Supreme Court, the next thing was the deputy registrar to give directions for the respondents, our opponents, to file their responses based on the appeal we had filed. But I was shocked immediately after the delivery of this ruling by a five-bench judge, namely Her Lordship, the Deputy President of the Supreme Court, Madam Philomena Mwelu, Justice Wanjala, Justice Joki Dumu, Justice Ranola, Justice Oko. They signed and certified the ruling was okay. Immediately after the delivery of this ruling, directions were given, without going to the records of the Supreme Court, that my appeal should be heard within 2 days. That is on the 14th. Because the judgment was delivered on the 11th. So we protested against this position, because the normal procedure of the Supreme Court is, and I want to repeat, once we file our appeal, respondents are supposed to respond and file responses on what we have filed. After the respondents do that, the deputy registrar is supposed to give up directions, instructing us now to respond on the responses filed by our opponents. So by then the respondents had filed nothing. We had also not filed further submissions to respond or to do a rejoinder on what is supposed to be filed by our opponents. At this juncture, we did a protest letter to the Supreme Court, and I have that letter with me, dated 12th July 2022. My lawyer protested and told the Supreme Court, no, it is unprocedural, it is wrong. There are no responses by the respondents and by ourselves. Then I'm happy the Supreme Court responded and did a letter to apologize on this mistake. I will give you all these letters. And I've got that letter of apology on the 12th. They did this letter on the 12th at around 4 p.m. via email. And the Supreme Court had this to say. The letter is dated addressed to my lawyer Namu. The petition number 11008 of 2022, Mike Mbobi Sonko versus the respondents. And I want to read sentence by sentence because it's just a brief one-page letter. Just allow me to read sentence by sentence. It's saying, I refer to the above subject matter in which directions were issued on the 11th of July 2022, the same day they issued the judgment on the preliminary objection which was ruled in our favor. Then they are saying it has since come to our attention that due to an inadvertent mistake, directions were not issued in respect to the petitioner filing submissions in support of the petition. Then they are apologizing to us. We apologize. This is the Supreme Court, not Sonko. We apologize for this oversight and hereby enclose further directions for compliance. Yours sincerely, Honorable Letizia Washira, Registrar of the Supreme Court. And this communication is copied to all the parties involved, over more than 11 parties involved. Yeah. Supreme Court admitting the mistake they did to us. They gave a hearing date. They didn't put into consideration whether we had filed our responses and the respondents. This was wrong. Now, instead of the Supreme Court giving us time, yeah, because we're not talking over 1 or 2, 3 affidavit pages, we're talking of over 30,000 pages. And all these 11 respondents, they were supposed also to file their responses. And then we were supposed to file further rejoinder of what they would have filed by then. Now, look at the directions which they gave. These are the directions of the court. These are the directions of the court. The court, there are two directions, and I want to go to them, all of them. The directions of the court, they are saying, further to the directions of the court, on the 11th, the day they were delivering the judgment of preliminary objection. They are telling the petitioner, do file and serve a soft copy of his submissions by midnight. By midnight of the 12th, the 13th. I'll come to that again. Then the respondents are at liberty to file and serve. Remember, this was supposed to have been done before they gave a new the date for hearing. Then the respondents are at liberty to file and serve a soft copy of the supplementary submissions by 10 a.m. 13th July. 10 a.m. We don't know what are their responses. So, but if they file by 10 a.m., we're supposed to take the responses of more than 11 opponents, 11 respondents. We go through page by page. Yeah? Then we reply also page by page and file. So they file by 10 a.m. on the 13th day of July. Then they're telling us also, the petitioner also, to file a rejoinder by noon. Noon of the 13th day of July 2022. Then also another task had tasked to us, all had copies of the file responses and submissions to be available at the court registry before 2 p.m. of the 13th day of July 2022. This time, the directions are signed by the Honorable Menek Pisabuli, a magistrate who is also a deputy registrar, Supreme Court. Now, I want to ask one question. How do you tell us to file responses on the 13th by noon, while the judiciary had given us a notice to appear for yet another judgment in Mombasa court between us and the IBC? And I want also to show proof of this. This is petition number E027, myself versus the returning officer Mombasa versus IBC Dispute Resolution Committee versus IBC itself and Wiper. And I want to read this. Take notice, the above matter, which was slated for judgment on 15th July 2022, has been rescheduled to Wednesday, 13th of July at 10 a.m. in open court. Yeah? This notice, merely we received it, we were not aware about the Supreme Court directions. But on the 12th, at night, we all left. All my lawyers on record, we left to prepare for this judgment. And remember, we are also preparing for an appeal in case the court in Gerul not in our favor. We are preparing and filing the appeal. So 13th 10 a.m. we are in Mombasa High Court. Then the Supreme Court expects us also 13th 10 a.m. to file our responses. And all my team of the clerks were in the High Court Mombasa. So we were denied justice because there is no evidence from our side that was put in court. Remember, there is a certain judge who presided over our was the presiding judge and the three-bench judge in our impeachment case. I want to mention his name because there are orders against us, restraining us from making any comments on social media and anywhere. So, there was a matter in the JSC where I was also a witness on my impeachment case against this judge. I want to mention his name. We took our evidence there. It was successful. The Chief Justice herself did a letter, a communication to State House, to the President, and confirmed that the judge was found guilty. This is the letter signed by Martha Pome, her lordship, to the President. that the judge who conducted my impeachment, he was found guilty of gross misconduct. And also State House, the President received a communication from the Chief Justice and took action. There is a tribunal that was formed by the President, and the judge was suspended. And remember in the investigations, the judge confessed that there was some interference in my case, that he met my opponents in his house. We have a video, a clear video, that there were some officers, some of whom have been fired from the State House, who came to mislead him to change my judgment. Talking with his own mouth. There's a very serious confession. There are some very dirty clips which are part of the tribunal evidence. And the judge is complicating also his own colleagues. How money used to be shared. He's confessing he has never lost any of his judgments before the Court of Appeal. He's mentioning how he normally takes money to the Court of Appeal. He's mentioning names of his colleagues. He's mentioning names of lawyers who take money to him. He's mentioning how when he takes money to certain judges, he always gets a commission. These are some of the clips that will play before the judicial, which we played in the JSC. And we're going to play in the tribunal. Another problem, I personally had a problem with Martha Koome. Number one, she went to a public TV station, a radio station, Spice FM, and declared her position that any impeached governor, Sonko being one of them, he's not supposed to be on the ballot. He's not supposed to vie until that impeachment motion is overturned by the courts. The same Chief Justice, I have a lot of respect for Martha Koome, but I want to tell her she's not above the law. As much as we respect her, she's not about to break, to defy the law. She went ahead and commented about any convicted state officer, public officer, is not supposed to be on the ballot until that sentence is overturned. Then I'm asking a question. The member for Sirisia, Honorable Weluke, was sentenced to 67 years imprisonment. What has made him to be on the ballot? When the Chief Justice was releasing these careless comments, was she aware that Weluke was a convict, cleared to vie? Was she aware? What does the Constitution say about her remarks? Yeah. I don't have any issues with Weluke, but Weluke was cleared pursuant to Article 99.3 because he had an active appealing vote, which is ongoing. Yeah. The courts cleared me by virtue of Article 193 sub Article 3 and 193 sub Article 2. So Article 2 says if you have been impeached, removed from office on violation of Chapter 6 by any law, you still have a chance to vie, provided you still have a pending appeal in court. And that is the position how we were cleared. But my question is, why did the Chief Justice decide to be a presiding judge in my matter while she knew I had an issue about that? I called for a press conference in Mombasa and I protested against her remarks. And on top of that, Chief Justice Martha Koome defied her own order on the BBI case. She issued a warning and order. I have a copy of that order. She warned Ahmed Nasir, the advocate. She warned Harvey. Yeah. There's a certain lady, a lawyer also was warned that in future, do not comment on any case that is pending in court, either on social media, public TV. So she defied her own order. She's supposed to sentence herself 6 months imprisonment. She's not above the law. In as much as we respect her, her conduct was wrong. And I'm a Kenyan, yeah, defended by the Constitution, which was promulgated in 2010. Another, which I might say is a forgery by the Supreme Court. She knew very well we didn't want her to preside over my matter because I had an issue which I addressed, which is in the public domain. They went ahead and confused us and issued another direction and told us the matter will be listed for hearing of the petition by a 5-bench judge. And remember, the preliminary objection was delivered by a 5-bench judge. Martha Koome was not a party to that 5-judge bench. And if they could have gone with a genuine position by telling us the matter will be heard by a 7-judge bench, we would have prepared an official recusal application for her to recuse herself, because she had already formed an opinion that Sonko is not supposed to be on the ballot. So this is a dirty trick that they played on us. Why lying to us that my matter will be heard? We applied verbally, because the matter was in the public domain. She was even criticized by lawyers, LSK members, that she was not supposed to do what she did. And we told Your Lordship, kindly recuse yourself because you had already declared your interest and position in this matter. She declined. The matter proceeded. The evidence of how this judge messed with my impeachment has not been filed. The evidence of what transpired in the Senate, further evidence and further evidence of the quorum was not filed. So she must have been serving the interest of somebody else. A case which has over almost 500,000 pages. Hearing, you're hearing it today. Then within 24 hours, you are delivering judgment. If we had a case in Mombasa for IBC, then the judges gave us a week to go through the submissions and deliver verdict. Even presidential petitions before the Supreme Court. Yeah, they take time, a week or 2 weeks. And parties are given time to file their responses under Article 50. Yeah. We are entitled to fair hearing, fair justice. Yeah. So unasikiza kesi siku moja, kesho yake unapeana verdict. Kesi iko na parties 14. Within 24 hours umesikiza saa ngapi every party. So there are so many technicalities here, and the conduct of the Chief Justice was wrong. I respect her. Sitaki kutupa maneno mbaya. I respect the judiciary, all the magistrates, judges, but when there is a problem, there is nobody who is above the law. Kama mimi na maswali zangu nimenyimwa haki, jaji wa mahakama anasema nilikudhulumu sababu ABCD na anaongea, na through the DCI and NSIS I reported the matter, and I was given a digest, and he was captured, even sharing money in the chambers. Hii ni jaji huyu na hapa napata commission yangu. High Court judge. Where are we heading as a country? The Chief Justice of the Supreme Court of Kenya, the President of the JSC, commenting on a matter that is pending before court, and she becomes the presiding judge, and she doesn't want to recuse herself. Our whole Supreme Court misleading parties. Our whole Supreme Court wanasema your money will be heard by a 5-bench judge. Then in the morning you find a 7-bench judge. Presiding judge ni yule ambaye wanasema ajiondoe, already ameshaambia dunia mzima, alikuwa kwa TV na radio, that impeach governor hafai kusimama. Na mimi nilikuwa impeach governor. Let us get a verdict based on justice, not shortcuts. Haraka ni ya nini? So we have filed for review before the same Supreme Court. We have filed also before the East African Court of Justice. And I want to tell also Kenyans, because see what of conversant na sheria, yeah, the East African Court of Justice is recognized by our Constitution under Article 2, sub-Article 4 and 5. Yeah, all the international treaties, international laws are being recognized. We are a member of the East African community, so we fall under that category. So mtu akisema asijui Sonko kwisha, so that is the end of Sonko, including new media. It is the start of Sonko, not the end of Sonko. Because we have been denied justice by how the Chief Justice conducted herself in this case. Nini game cost, asema Sonko was in the media complaining about my conduct, complaining about the remarks she made on a public TV and radio station. So that was not fair. We need to be given time to file all our evidence. Najua, they are covering those clips, they are very dirty clips. This judge really complicated his colleagues. He was acting as a broker of the judges. Not all the judges, there are judges who are very good. The magistrates who are very good, they follow the law. Na kama kuna interest mtu amemapproach judge anajitoa, magistrate anajitoa, no. Somebody approached me on this case, I don't want. I'm recusing myself. That is the law we want. Martha Koome is not above the law. Yeah? It's not above the law. I'm consulting. I might also be forced to file a complaint against her in the JSC. And she must accuse herself with the JSC when her complaint goes there. Yeah? Because there is evidence. Yeah? Evidence. Yeah. And is there any other question?
Just a question. Are you saying that you were not given enough time to file your submissions at the Supreme Court?
Yes, we are not given time. As per the judgment of the preliminary objection, the judges are saying my appeal was filed on time. Page 3. I want to take you there. Yeah? I want to take you there. We now determine as follows. Yeah? I'll skip because of time. There is also no doubt that the appellant filed his petition of appeal on this court's online platform on 4th of April 2022. Why they didn't pick up this case since April? Why now that have been cleared by IBC? Okay, after they picked the case, you are finding fair hearing. Why don't give me fair hearing? And you are part of the evidence. If you are the one who forwarded the summary of your judgment as the head of the Judicial Service Commission to the President, and the President took action, it means the evidence I had was sufficient. Then why refuse me to bring that evidence before the Supreme Court? Yeah. This judge messed with my impeachment. I was a witness. I testified. My testimony, my evidence made you forward the findings to the President. The President found this judge was guilty. He suspended him. He formed a tribunal. Why are they blocking that evidence? Because the clips are there, they are dirty. There are clips even judges transacting in chambers. Dollars, money. Even they were arrested with money in their pockets. Wakadanganya ni school fees. Hizo ni pesa. Zingine ni za mawido wamenyang'anywa mashamba, wanapea mabonyenye mashamba. If a person like me can be denied justice, why are we heading as a country? I still have my political muscles. So this is wrong.
My last question. We know that the Supreme Court did not pronounce itself on whether an impeached governor is free to vie for any political seat after he's impeached. And going to that, we know that you still have the certificate. Have you communicated to IBC, or IBC has it communicated to you in terms of trying to revoke that certificate after yesterday's ruling?
You see, at the moment I'm dealing with my fate. I cannot allow one person to mess with my life. Even if I'm found guilty, let us deal with the law. I filed my appeal since April. Why now that I've been cleared, some few days after I've been cleared, you want to expedite this appeal? You want us to do everything at midnight? Okay, check our diary. Give us a free date, which we are not busy, but we're in Mombasa with all the lawyers. By that time we're in Mombasa, we're telling us to file hard copies. And all the lawyers and clerks are in Mombasa for the hearing of the IBC case. And if they have admitted, you know, I'm not giving any hearsay evidence here. They admitted We apologize. This is the Supreme Court telling me as a petitioner. We are sorry. We didn't know that we will not find further evidence. So we apologize, but that being the situation, we must proceed at all costs. We must proceed at all costs. Whose interest were they serving? I'm entitled to fair hearing. I'm a Kenyan. Whether I have cases, I'm a Kenyan. These are all political cases. I should be given time to defend myself in any court of law.
Has IBC contacted you in terms of their certificate?
No, IBC are parties to this case. It's an independent body. But what we know as of now, I still have an active appeal. Yeah. By yesterday, I didn't have any appeal. Yeah. I didn't have any appeal. And I want to give an example. Mother Kome, I'm sorry, I'm confusing these two names. Mother Karua, when she filed a case against Anwar Guru as the Attorney General, and IBC that time, she didn't get justice in Kenya over some issues of costs. She lost in the High Court. Mother Karua lost in the Court of Appeal. Mother Karua lost in the Supreme Court. But she got justice as the East African Court of Justice. And it is also captured in the Kenyan Constitution. So, whoever is saying that is the end of Sonko, he's lying. It is the start of Sonko. Because I have an active appeal also now. Another one. A fresh one. Yes. So, sasa when I see you, wale walikuwa wanasema sitakuwa kwa deni.
Don't you feel delayed by the various court suits that you are facing?
It depends. For instance, kama hii kesi, it depends. Vile hizi kesi zimeletwa, vile zimepatikana. 1,000,000% they are political cases. And I want to go to the merits because I have a lot of respect actually na wale magistrate wako pale chini wanafanya zile makesi. Sitaki kuzitaja. Yeah. But the law is also very clear. You cannot be convicted on hearsay evidence. All the allegations in my political impeachment were politically instigated. You all saw the day the Senate was closing for the season, before the elections. All senators, including ODM senators, Tanga, Kenya Kwanza senators, ODM senators, including Kina Orengo and Senator Mazao, who is a former judge, they are saying my impeachment was wrong. One of the senators said it was acquired through bribery because I differed with some state officers, government officers. And the cases of abuse of office are still pending before the anti-corruption courts. The only person who was convicted, 67 years, was Weluke. In fact, kesi yangu ni rahisi zaidi kushinda yule amepatikana guilty na akafungwa. First, there was no quorum in the county assembly. I had over 60 MCAs in Kwale. Yeah. First we were over 100, tukapigwa tear gas pale Riverside. Tukatoroka na msitu tukaenda kujificha Kwale. So there was no quorum, there was no roll call. If you vote, lazima useme maybe ni Job Maora, Githurai Ward, apiga no ama yes. There was nothing like of the sort in the county assembly. Yeah. Said that there was no public participation. And the same presiding judge, this is what he was telling us. Anasema na iko captured, nilibidi ni wachane na hiyo judgment ya Nairobi because wale watu walinifuata kwangu kwa nyumba. Anaongea mdomo yake si Sonko. Akataja majina. Akataja majina the mover of the impeachment. Akataja majina ya one lawyer ambaye alilipwa na county 300 million. Nataka kutaja jina pia kuna na wale yangu. Akatoboa yeye mwenyewe. Akatubia hii mambo shit tumezoea kuifanya hata usijali. Tuko sawa nini. And there was another matter, ilikuwa na yangu ya impeachment, kesi ya shamba. She was impeached by the court of appeal. He told us, vile alikuwa anafanya court of appeal, vile atafanya. Court of appeal. Anadili na nani, anatuambia, anataja majina wale, anataja na dili nao. A whole judge of the High Court. So waliharakisha judgment yangu, they were blocking because niko na barua ya kwenda kwa tribunal pia. Kutoa evidence. Hello. So they can also be trying to sanitize one of their own. Why hakutaka evidence yake ingie? Kwa sababu wametupatia directions now, petitioner, bring your further submissions. There's a BBI case, there's a precedent that was set. I set a law firm, a lawyer, sought for leave in the Supreme Court, or the Court of Appeal, to file additional evidence. It's allowed, it's in the law. Yeah. So that's what we are supposed to do that. We have filed submissions to seek for leave of the court to bring further evidence of how the High Court judge messed with my impeachment. Na katuambia vile bado wangedeal nayo Court of Appeal vile alikuwa amepangiwa. The best wangesema rudi ni trial was a case fresh, so that we give all our evidence instead of ending my life there. And they know the technicalities which were there. And I want to repeat myself. One, Martha Koome took sides, yeah, by commenting on public TV. She defied her own order she issued during the Supreme Court BBI case. Another technicality, this is like forgery they did. This is like forgery. And I want people to record statements here. Why tell parties the matter will be heard by a 5-judge bench? Then without giving another notice of telling us the bench will be changed to 7, tunaenda kuona 7-bench judge. That's also a technicality and it is wrong. This is misleading. Why lie to Kenyans that are convicted member of parliament or an impeached governor is not supposed to vie? While the constitution inaongea kivengine, it means that the constitution haielewi. So she's not above the law. They have infringed my rights. I have the right of complaining as I wait for the next course of action, which we have already filed.
So in short, you are not giving up?
I'm not giving up. Nimedhulumiwa, why should I give up? Wangenipatia time ya fair hearing, fair trial, nipate fair justice. Fair justice. And nimekwambia nimeyaklini. Presiding judge anasema judgment yako ya congregation hii. Remember my judgment was read at 10 p.m. Do you remember there is one judge who refused to be with his colleagues? Even this Supreme Court ruling, there are 3 judges who are not involved in writing of the judgment. They've just seen a sentence saying, these other ones, they will write their judgment later, but they are concurring with us. Something is wrong somewhere. Something is wrong somewhere. Na haraka gani, kesi tumesikiza leo, over 14 parties. Unapenda ruling kesho yake. My appeal has been there since April. Kwa nini kuiharakisha before elections, the party verdict? Why now that I've been cleared, unaharakisha unamalizia haraka? Unasema vitu za nani?
Asante Governor. Mko sawa? Your time, eh?